Hello everybody, this is Dr. Cole. It is Wednesday evening, June 18th, and this will be the Week 7 video for Political Science 1013 for the summer 2025 term on the first 7-week schedule. Everyone, I'm getting this message out early. I'm not waiting until the weekend. The problem is, it's the 18th and our final exam is the 27th, so we have 9 days left until the final. I like to get one message out for each unit of the course, and there are 8, but it's only a 7-week term. So I'm going to go ahead and get this message out today and get another one out, the last one of the term, early next week. Maybe not Sunday, but Monday or Tuesday perhaps, before the final on Friday the 27th. Everybody, quite a bit has been going on the past week or 10 days. I mentioned in the message I sent out over the weekend the conflict that has broken out between Israel and Iran, and that is still ongoing, and it is not clear how it will be resolved or what the United States involvement will be. It's not the only thing that's been going on. Over the weekend on Saturday, we did have the big military parade in Washington to commemorate the 250th anniversary of the Army, also coinciding with the President's 79th birthday. So that went off, and at the same time, there were any number of demonstrations around the country against the Trump administration on what had been proclaimed No King's Day. And there was a large turnout for a good many of those. So that attracted a lot of attention, both those events, the military parade and the demonstrations. At the same time on Saturday, perhaps most alarming of all, we had a political assassination carried out in the Minneapolis area. 2 couples were targeted. One member of each couple was a member of the Minnesota legislature. One couple was shot to death. The wife in that couple, the woman, was a former speaker of the Minnesota House of Representatives. Another couple was similarly targeted and shot, but they are hospitalized, and it looks as though they may recover. The gunman has been apprehended. The motive is unclear, although a manifesto of a sort was recovered from the gentleman's vehicle, along with a list of other Minnesota politicians he might have targeted. So this is quite alarming when you consider the context of the 2 assassination attempts against presidential candidate, as he was at the time, Donald Trump, over the summer, and more recently a firebombing attack on people demonstrating on behalf of Israeli hostages in Boulder, Colorado, and before that, the murder of a couple, both of whom were pro-Israeli activists and engaged to be married in Washington, D.C. So this is all quite disturbing and alarming, and has got people wringing their hands, of course, about the prospects for further political violence in the United States. And as you might expect, people on both sides of the partisan divide are pointing their fingers at each other because of these events that have taken place over the past few months, going back to the election campaign last year, and now more recently just over the past weekend in Minneapolis. So, at the very least, these are all things we need to be aware of. Well, everybody, for the remainder of the term, what we have is, next week we're going to have our last discussion on Monday and Tuesday. That will be the 23rd and 24th. After the exam finished up on Monday, we got a series of announcements out. There were half a dozen of them altogether, I believe. And the discussion topic is mentioned in one of those. So check your inbox if you have not seen those. So we'll do the discussion next week on Monday and Tuesday. Term papers, if you're doing one, that will be due Thursday the 26th, and the exam will be Friday the 27th, with grades due Monday the 30th, 1 week from this coming Monday. Now there are 4 articles to be read, as in the past, 2 of them to do with the Supreme Court and 2 having to do with Congress. We have 2 sets of class notes, 1 on the Supreme Court, Unit 7, and 1 on Congress, Unit 8. I'll talk about Unit 8 on Congress next time and say a bit more about the readings for the exam. For now, let me try to go over very quickly what we try to do in Unit 7 on the Supreme Court. Everybody, we start out talking about the court system in general. There are 92 district courts around the United States, then 11 circuit courts of appeal, plus the Court of Appeal for the D.C. Circuit and for the Federal Circuit. Those are 2 separate and distinct circuits, the D.C. Circuit and the Federal Circuit, although they're both domiciled in Washington, D.C. Now, the Court of Appeals for the Federal Circuit takes appeals from certain special purpose courts, such as the Court of International Trade that students might have heard recently ruled against President Trump's tariffs. But the Court of Appeals for the Federal Circuit put a stay on that until they can be fully briefed and have that case fully argued and make a full decision on it. So for the time being, the tariffs are still in place. But in Unit 7, we're mainly concerned about the United States Supreme Court, which hears almost all its cases on appeal. We mentioned in our class notes a couple of special categories of cases in which the Supreme Court does have original jurisdiction, but that really can be ignored for our purposes. Most all their cases will come to them from either one of the circuit courts of appeal or a state Supreme Court. Now, we discuss Supreme Court procedure. The court typically might take between 50 and 200 cases a year. More recently, it's been 100 or fewer out of many thousands that might be appealed to them. If they decline to take a case, then they'll simply state that they're doing so without any further reason. And that means the lower court decision will stand. Okay, but 100 or so cases per term might be typical. The term runs from October to June. It will end at the end of this month. Some decisions were announced today, Wednesday, as I'm speaking to you. And the remaining cases yet to be decided or announced, we expect to hear by the end of the month. Sometime they go a little bit past July 1st, but we expect it to be the end of this month that they wind up their business. Most of the work of the Supreme Court consists of going through a huge volume of legal briefs for each case, which they'll do with the assistance of their law clerks. They then will schedule cases for oral argument, generally half an hour for each side, 1 hour altogether. It's quite brief and almost perfunctory, although sometimes something will happen in the oral argument that will change someone's mind. Then they'll meet weekly in conference to discuss the cases that have already been argued. It may take a few weeks for a decision to be arrived at. The writing of a majority opinion has to be assigned by either the Chief Justice or the Senior Justice in the majority if the Chief Justice is not in the majority. That will be circulated for Justices' comments, perhaps rewritten to satisfy one or more justices. And then finally, ultimately, a decision will be announced, and generally there will be a majority opinion that will attract the support of at least 5 of them, so that will be the opinion of the court. There can also be dissenting and concurring opinions. Okay. A dissenting opinion from a judge, justice in the minority may at some future point be the basis for a majority opinion if the court decides to reverse itself. And that can be important. Concurring opinions go along with the majority on the treatment of the parties to the case, but may disagree with the legal reasoning involved. They say that very often a concurrence is a dissent in all but name. Okay? So be familiar then with how the court does its business. Now, after that, everybody, we have a section in the class notes called the Supreme Court as a Political Institution. And people will say, well, it really shouldn't be a political institution. It's a legal institution. Be that as it may, it's been hard in recent times for us to keep the politics out of the Supreme Court. And that can be seen especially when a vacancy occurs and a new justice has to be nominated and confirmed. The justices themselves and prospective justices, whose names may be discussed when a vacancy occurs, routinely are described as liberal or conservative or middle of the road. Right now, it's typical for people to speak of the Supreme Court as sort of a 9-person national mini-legislature, with Republicans currently holding a 6-3 majority based on the political party of the president who appointed the various justices. Now, the justices themselves would be very quick to tell you that sometimes they divide along those lines, 6-3, but other times they do not. They don't always, and are always predictable according to the political party of the president who appointed them. Okay. They're not supposed to think of it in exactly the same way that a member of the legislature would. Okay. The member of the legislature is thinking in terms of his or her political preferences, but judges have to set that aside on the Supreme Court. The justices do. And whatever they might prefer, looking at a piece of legislation, they have to consider whether or not it's constitutional based on their understanding of what the Constitution permits or requires. Now, we have a discussion of the concept of judicial review that makes the Supreme Court a constitutional court, which simply refers to the power to decide whether something is constitutional or not. The idea being is that the Constitution is higher law and trumps all other bodies of law. So if anything else is in conflict with the Constitution has to prevail, and so another law may have to be declared unconstitutional. And the first time that happened was in the famous case of Marbury versus Madison in 1803, when Chief Justice Marshall claimed this power for the Supreme Court for the first time in controversial circumstances, and it turned out everyone accepted it. It was though sometime after the ratification of the Constitution, and until then it wasn't really clear whether the Supreme Court would be able to claim that power for itself or not. But anyway, getting back to the matter of the politics of the Supreme Court. Recent vacancies and nominations to the Supreme Court have been highly politically controversial, politically charged. That's been true going back at least to the 1970s. The issue of abortion had quite a bit to do with that, but not that alone. We go through several controversial episodes, highly politically charged, highly theatrical occasions, when vacancies occurred on the Supreme Court and nominations had to be made. There was President Reagan's nomination of Judge Robert Bork, who eventually was not confirmed. There was President Bush 41's nomination of Clarence Thomas, who was confirmed, but not before Anita Hill made highly sensational allegations against him. He was confirmed in spite of that. All three of President Trump's nominations, Gorsuch, Kavanaugh, and Barrett, were controversial for somewhat different reasons. The circumstances were a little different for each of them, and we discussed those in the class notes. So it's been very difficult to keep the politics out of the Supreme Court in recent times. Nominations also can be matters of political recognition for one group in the population or another. For instance, Clarence Thomas succeeded Justice Thurgood Marshall, who was the first African-American Supreme Court justice. So that seat informally became known as the black seat on the Supreme Court, because there became an informal expectation that that seat would be filled by an African-American. There have only been, well, we have Justice Jackson now, who's the third African-American to have served on the court. Justice Sandra Day O'Connor was the first woman to be named. We now have 4 women on the Supreme Court. Justice Sotomayor is of Puerto Rican descent, so It's unclear, but it could turn out to be the case that there will be an expectation that that is the Hispanic seat on the court. This kind of thing has taken hold on the Supreme Court at various times in its history. Earlier, if we were to go back way back in the first half of the 20th century, we would have found at various times there was an expectation that there would be a Jewish seat and a Catholic seat on the Supreme Court. So expectations about that kind of thing have changed over the years. We talk about various ways in which the Supreme Court can be checked and balanced. Justices can be impeached and removed, but no Supreme Court justice has ever been removed. There was one attempt a long time ago to impeach and remove a justice, but that was unsuccessful. You could try to overturn a decision by means of constitutional amendment. For instance, that was done with the 16th Amendment to permit Congress to impose an income tax after the Supreme Court had declared such a thing unconstitutional. But maybe the easiest way, and there really is no easy way, but maybe the most practical way to check and balance the Supreme Court is to nominate justices when vacancies occur with views different than the justices they're replacing. President Nixon did that. President Bush 41 to some extent, really both Bushes. President Reagan did it, and President Trump has tried to do that. Okay, with some success in Trump's case. 3 of the 9 that are serving now are his appointees. Okay, so it's hard to separate politics from the Supreme Court. Now, everyone, what we do after that is we discuss several so-called landmark decisions of the Supreme Court. Going back to the 1950s, there was the Brown decision, Brown versus the Board of Education, which prohibited segregation in public schools. So you can no longer have a jurisdiction that operates 2 sets of schools, one for black students and one for white. Okay. Schools have not been completely integrated. Okay. Students still tend to attend schools where members of their own race predominate. The Supreme Court, 20 years after the Brown decision, was not willing to order integration across an entire metropolitan area where there might be perhaps dozens of independent school districts. That enabled white fights. Okay. If an inner city school system were to be desegregated, people might flee to the suburbs to escape integration. And the Supreme Court was not willing to block that 20 years after the original Brown decision. Another thing about the Brown decision was there was a second decision the following year when several of the school systems involved asked the Supreme Court for further instructions about how to implement that decision. And the Supreme Court told them they could do so. They had to go ahead and desegregate, but they could do so with all deliberate speed. All deliberate speed. Well, that looked like almost a contradiction in terms. But what it meant was the Supreme Court told them to desegregate, but they could do so gradually, which meant that the thing was strung out as a political issue from the 50s at least until the 1970s. And it is still something of an issue because in spite of all those decisions, most students still attend schools where members of their own race predominate. All right, then we have the Dobbs decision, which overturned the Roe versus Wade decision. Roe versus Wade going back to 1973. Dobbs, the date of that I believe now was 2022, just a couple of years ago. Okay, and of course those decisions had to do with abortion. The Supreme Court controversially found that the Constitution implied a right of privacy, which implied that there was a right for a woman to choose to have an abortion. That's what was found in 1973. But with the passage of time, more and more justices were appointed to the court who were skeptical of that decision. President Trump made a point of appointing people that he was fairly confident would vote to overturn Roe versus Wade, and they did so in the year 2022, and the matter now has been returned to the states, as they say. So some states have extremely permissive abortion laws, others are far more restrictive. So Roe versus Wade was overturned by Dobbs in 2022. We discuss the Citizens United decision, which overturned some of the campaign finance laws Some spending and donations to political candidates still could be restricted, but independent expenditures could not. Expenditures that were not tied to a particular political party or candidate could not be restricted. They found that was a violation of the First Amendment. And that led to the rise of so-called super PACs, super political action committees, in support of one or another political candidate or party, even though they could not coordinate their activities with that candidate or that party to remain independent. It was independent expenditures that could not be restricted. But that opened the door to much, much more big money in political campaigns, including but not limited to presidential election campaigns. The Obergefell decision, okay, in which the Supreme Court found that right to privacy, related rights, due process rights, rights granted that the states were compelled to recognize under the 14th Amendment, implied that there was a right to marriage even for couples of the same sex rather than the opposite sex. Okay. Going back a decade or two ago, Obergefell v. Hodges is the name of that decision. And you'll notice from our slides that we gave you, Justice Anthony Kennedy, who's now no longer on the court, replaced now, I believe, by Justice Gorsuch, was the author of that decision. And you'll notice that Chief Justice Roberts dissented very vigorously from that decision. But that decision is still in place. Obergefell v. Hodges. All the states are required to recognize same-sex marriages. Then very recently, just last year, we had the case of Trump versus the United States, in which the Supreme Court very controversially found that presidents were immune from prosecution for activities related to their core constitutional duties. Okay. And Justice Sotomayor in dissent speculated, well, what if the president ordered the Navy SEALs to assassinate one of his political opponents? We would hope it would never come to that, but that's a possibility that she raised in dissent in the case of the United States versus Trump. The decision divides presidential actions into three categories. Official acts related to core constitutional duties are absolutely immune from prosecution. Okay. Official acts not so closely tied to core constitutional duties, there is a presumption of immunity, but that presumption conceivably could be overcome. Okay. Then there are unofficial acts, and Chief Justice Roberts was quick to say, not everything the president does is an official act. Okay. What's not an official act, there's no immunity. And that might cover actions that a president took as a candidate for re-election. Now, you might have heard there were several prosecutions ongoing against then candidate and former President Donald Trump in the run-up to the 2024 presidential election. He was convicted in one of those cases, the so-called hush money case, but the judge in January, just before he was inaugurated, did not sentence him to any prison time. Okay. The other prosecutions all have been either suspended or dropped now. In the case of the state of Georgia, there's an issue regarding the prosecutor who may have to be replaced if that prosecution is ever to go forward. The other two prosecutions, I believe, have been dropped. But Trump versus the United States did stipulate that in actions related to the president's core constitutional duties, there was absolute immunity from prosecution. So if a president were to be punished for something like that, he would have to be impeached and removed from office by the Congress. There's no other recourse if it's an action related to the president's core constitutional duties. Okay, everybody, that's enough for this time. We're going to get one more video out in not quite a week from now, more than likely Monday or Tuesday next week before the final exam on Friday the 27th. And there will be a discussion, our last discussion on Monday and Tuesday the 23rd and 24th. Term papers, if you are doing one, are due Thursday the 26th. I sent messages out to 3 students who need to make up exams. You know who you are. It will help you to get through the course successfully if you can make those exams up. So please contact me. Contact me, anybody, any of you with any problems, issues, or questions through the course website or at david.cole@opsu.edu. We'll be talking to you again in a few days for our last message before the final exam.